Hello, my name is Steve Adams, Stephen R. Adams, NotGuiltyAdams.com. And if you're watching this video, it's because you or a family member have been charged with domestic violence. And it's important to listen to this video so you know what's going to happen throughout the case after you have been arrested. Now, what is domestic violence? Domestic violence is where someone allegedly causes or attempts to cause physical harm to a family or household member, your wife, your spouse. They also have a definition for person living as a spouse, boyfriend-girlfriend relationship, and the state can prove that you're living together. How do they do that? Are you getting mail at the residence? Is there evidence from neighbors that you've been living there? That is an element that state will have to prove. Also, there's recklessly causing physical harm to a family or household member, and there's different varieties of domestic violence. And if you allegedly cause serious physical harm to a family or household member, you'll be charged with felonious assault and domestic violence, and no one wants a felony. And by the way, if you're a repeat offender for misdemeanor 1 domestic violence and you get another one, that will be charged as a felony. Now, what happens to start a domestic violence case? Well, typically what happens is someone calls 911. It could be your spouse. It could be a neighbor that's hearing screaming in an argument. It could be your child. And then once the 911 operator gets that call, the police are going to be at that household right away, or within a few minutes. Now, what should you do if you're there and someone calls 911? What should you do? Well, if you're not the perpetrator, stay there. If you are the perpetrator, stay there, because the police are going to arrive, and if you have done something, or if you've not done something and you leave, there's going to be an inference that you left because you're guilty. So stay at the scene, cool off, go outside, and wait for the police. Now, when the police arrive, are you going to spill your guts? No, you're not. You have a right to remain silent, even though you're not under arrest. Now, let me explain something that's important. When the police arrive, all they have to do is determine whether or not there is probable cause to arrest you. Would a reasonable police officer believe, based upon evidence that they see, hear at the scene, and statements of witnesses and people in the household, when they look at the totality of the circumstances, do they have enough evidence to charge you with domestic violence? That's what the police are considering. Now, probable cause is not proof beyond a reasonable doubt. In fact, on a scale of 1 to 10 or 0 to 100, probable cause lies somewhere between 30 and 35% on that scale. But they can arrest you on that type of a scale, so beware. In addition, the police will want to talk to you. Now, if you believe that you've committed a threat or some harm to somebody, do not talk to the police. Remain silent, because what they're going to do is pigeonhole you. And they're not going to want the whole story, the whole truth, and nothing but the truth. They're going to get bits and pieces and use it against you. And if you go to trial and you want to explain something like self-defense, defense of others, or you needed to expand upon why they were charging at you and you did what you did, save that for your lawyer, save that for court. Do not tell the police. Why? Because you don't want the prosecution game planning on how they're going to shut your story down. Because obviously things, when you're excited and it's an intense moment, you're not going to say everything. But upon reflection, you'll remember more. So you don't want to pigeon yourself into a story at the scene. be quiet and say, you know what, I think I'm going to wait to talk to a lawyer. But if you're sure that you haven't done anything wrong, tell the cop, I didn't do anything wrong. I didn't commit this crime, and that's how I'm going to leave it. Because then they're going to have to determine whether or not, based upon that statement, they got other evidence to charge you. So, and by the way, remember this, typically the police are biased when they get that 911 call because they're going to know whether it's from a male or a female, typically. And they're going to believe that the person that made that call, or they're going to have a bias or a preconceived notion that the person that made that call is a victim. So you need to be aware of that as well. Now, also be aware that at the scene, the police are wearing body cameras. They typically separate the parties and try or attempt to get a statement. And they have cruiser cams that can record all of these things. So you need to be calm, cool, and collected. And typically in a situation like that, no party's calm, cool, and collected. It's an emotional nightmare. So remain silent, save it for your lawyer. Now, once the police decide, based upon their short review of the evidence, they're going to make an arrest. I hate to say this, but typically it's a male that get arrested. It's the male and the person that first calls a 911 operator. So if you didn't call 911 and you're a male, you probably got issues here. But remain silent, keep calm, keep cool, do not argue with the police. It will only hurt you, it will not help you. Save the truth, save the story for your lawyer so that he can help you fight this case, challenge their evidence, challenge their probable cause, and find a judge or a jury that will say not guilty in a circumstance like this, assuming the facts are there to do so. Now, what's going to happen next? You're going to be placed under arrest. And then the cops should Mirandize you. In other words, those Miranda warnings, you have a right to remain silent. Anything you say can and will be used against you. You have a right to have an attorney present during questioning, etc., etc., etc. You're not going to have a lawyer at the scene. So don't answer any questions. And by the way, before the arrest, the police officers are allowed to ask you questions. Why? Because they allegedly have not made an arrest decision yet. They have not found that probable cause, so they're trying to figure out what's going on. And if you make a statement and it's damning to you, like, yeah, I did whack her in the mouth, that's a problem because you don't have to be Mirandized. That's an admission against your interest while the cops are investigating the case. They do not have to Mirandize you while they're investigating. They have to Mirandize you after the arrest or when a reasonable person would believe that they're under arrest. Now, you may get arrested. What happens then? At that point in time, you'll be handcuffed, placed in the back of the police cruiser, and transported to a jail for processing. And at the jail, they'll have pretrial service workers, and they'll collect information from the police and from you so that the next day, the next morning, you can have an arraignment and a bond hearing. Now, here's what the judge is going to consider at your arraignment. He's going to listen to a statement from the prosecution. Perhaps the defense attorney, a good defense attorney, will give some sort of a statement on your behalf, especially if there's a good defense or you did nothing. Now, what happens next is the judge will also review or had reviewed a pretrial services report. That report will include things like whether or not you have a criminal record, whether or not you have a prior domestic violence on your record, whether or not the victim went to the hospital, whether or some report about the injuries that the alleged victim sustained in this alleged incident. He will review whether or not you are gainfully employed. He will have information about how many children, if any, you have in the household. He will have a report about what witnesses allegedly saw this take place. And from that information, he will determine a bond for you. Now, typically, if you're a first-time offender with no record, you're typically going to get an OR bond unless the injuries that are allegedly sustained are really serious. Or if the victim, for some reason, fears you will come after her and has legitimate evidence to support that. But typically that's not the case. Typically for a first-time offender, you're going to get a low or an OR bond. An OR bond is basically where in writing you promise to show up to court and all the court appearances and cooperate with whatever conditions of bond the judge imposes on you. However, it could be a monetary bond. And the more serious the offense, the more you have of a criminal record perhaps, the higher monetary bond you will most likely obtain. And that could be, for example, a $50,000 bond at cash or at 10%. If it's 10%, friends or family are going to have to post $5,000 to get you out of jail. Now, for first-time offenders in particular, an OR bond will be granted, but there are conditions associated with that bond. Domestic violence is treated very differently than any other crime. For example, they may impose house arrest, where you'll have to wear an ankle bracelet and you can go to work, you can run some errands, but you're on tight time constraints, and outside of work, a few errands and maybe grocery shopping for a short period of time, you're going to have to remain in your house. House arrest. It's also known as the electronic monitoring unit. Also, the judge or the court system, people helping the judge, have 48 hours to get a hold of the alleged victim to determine whether or not the victim wants the jurors monitor unit imposed upon you. What is that? Well, the court can determine whether or not you go within a certain distance or radius from the victim's household. And if you do and you get too close, the court will be alerted, probation will be alerted, and the victim will be alerted. And once they get you, you will be placed back in jail. We don't want that. The court will definitely want you to sign a temporary protective order. That's where you agree to stay away from the victim and not communicate with the alleged victim at all. Not by phone, not by telecommunication, electronic communication, or by a third party that you say something to and you want them to relay it to the alleged victim. None of that's permitted. You must stay away and not communicate with the alleged victim at all. If you do that, you prepare with your attorney your defenses and go to trial. And if you prevail, that TPO will dissolve and it will be over with. Now, while we're speaking about trial, what happens after you plead not guilty? What happens after your bond is set? Well, if it's a monetary bond, your friends and family can post that. And once you get out of jail, you'll have to report to probation and be assured that you're aware of what the TPO conditions are. Get your ankle bracelet on for house arrest or juris monitor as well. If you get an OR bond, you'll be released that day, or maybe that day. You might have to stay in jail a little longer for the court to get a hold of the victim to determine whether or not they want a juris monitor unit on you. But you'll be released within 2 days. And from there, you'll have to abide by the conditions of probation and any stay-away orders that are imposed by the court. But you will be able to talk to your attorney. You will be able to go to work. You just must stay away from the alleged victim. And sometimes the kids can be a part of that stay-away order if the wife believes that you're a harm to them as well. That's possible. So, the case is pending. What do you do now? Well, number one, you need to hire, if you haven't already, a skilled lawyer so that the lawyer can work on your defense. Listen to the facts. Get the facts from the prosecution, listen to your facts, and come up with potential defenses for trial. For example, do you have an alibi? Were you even there? Is she making the story up? Is this a case about self-defense or defense of others? What did she do to cause you to react and strike her? Did you strike her more than once or not? The attorney is going to want to figure out all the facts so he can properly establish defenses on your behalf. Also, he wants to establish what's up with the prosecuting witness. What's up with the spouse? Do they have a history of mental sickness? Do they have a propensity to be violent? Did they go to the hospital? What did they say to the hospital? How were these injuries sustained? There's a lot of information that your attorney needs to get to properly defend you and establish certain defenses. So the attorney will work on that, and ultimately it will be set for trial. You have the trial. If you're found not guilty, great. If you're found guilty, there are problems associated with a guilty finding. For example, if you are found guilty, you cannot own or possess a firearm. And by the way, during the course of discovery and while the case is pending, you will not be able to possess or own a firearm as well. But if you're convicted, that's gone. And by the way, a domestic violence conviction can never be expunged from your record. And that's a problem because what happens? Most employment applications ask you whether or not you've ever been arrested or convicted of a crime. And they can also do a criminal background check. It's going to show domestic violence. And many employers may not want to hire you because of that. So you definitely want to make sure that you hire the right attorney who's going to be on your side and establish your defense effectively to present to the trier of fact in hopes of getting a not guilty finding. Or negotiating a deal that does not involve a domestic violence conviction, but some other offense that perhaps can be expunged at a later point in time. In addition, if you're convicted, you will have stay-away orders. You may have house arrest or electronic monitoring if the judge decides that they don't want to put you in jail. And by the way, for a misdemeanor 1 domestic violence where there's an allegation that you harmed or attempted to cause harm to the victim, that's a misdemeanor of the first degree and carries from 0 to 180 days in jail and up to $1,000 fine. So there's jail time, fines, fees, probation, electronic monitoring, house arrest, other community service. By the way, the judge can order you to get counseling. Whether it's mental health counseling, anger counseling, counseling most assuredly will be a part of your probation. So you need to be aware of these things. Make sure your attorney knows about these things. Particularly right now during COVID-19, these are extraordinary times. Everybody is at home, the wife, the husband, the kids. They're working, they're stressed, they may have been laid off, they may have been furloughed. These are stressful times. In stressful times, you need to remain calm, cool, and collected because tempers can flare. And what's interesting at this point in time, the police are not really making many arrests except for accidents, perhaps, large, big-time felonies. But you know what? You know what's common during these times from what the police tell me is domestic violence because stress levels go up. Impatience is there. Stress, impatience leads to people losing their temper and maybe going to threats or pushing or shoving, whatever, but you got to be careful. And I'm not condoning domestic violence. I'm just saying, really, through these times, keep calm, keep cool. But by the time you're listening to me, something happened. So for those of you that haven't been arrested but are just watching these videos, really take a deep breath before you respond to a spouse, because if you act instinctively or impulsively, it may lead to the police coming to your house, and we really don't want that. You don't want that. It's too risky, and it will just add to the stress at a stressful time in history. So folks, if you're listening right now and a family member or loved one has been charged with domestic violence, feel free to give us a call. We do want to work with you to help you get through this extra stress and help you establish defenses, or at the very least mitigate the situation. So feel free to give us a call. We all have experience here with domestic violence cases, and we'd be honored to help you out.